Thanks so much, Maggie. Yes, Kelly and I have been practicing matrimonial and family law exclusively for a combined over 20 years, almost 25, I think. And we're going to talk a little bit today about sort of an overview of financial and custodial concerns to think about if you're preparing for divorce. So I know we're short on time today. It's a fairly brief presentation. I just want to make sure that everybody knows we want this to be as helpful to you as possible. So if you have specific questions, or as we're talking, if you think of something that you'd like for us to address, please go ahead and type it into the chat box that you can all see at the bottom of your screen. For those of you who are not Fuse literate, at the bottom of your screen, there's a little icon, chat icon. And if you click on that, there's a place at the bottom to type a message. And if you type a question in there, we're going to do our best to address those as they come up throughout the presentation.
Thanks. So as Emily said, we have only about 30 minutes, and our goal is to cover not so much from a 30,000-foot view, but a pretty high view, all the issues that you will consider in embarking on a divorce. And there's a good amount of them. So here's what we're looking to cover today. We're going to break it out into financial issues and custodial issues. And you'll see on the slide that's on the screen right now, the financial issues we'll be discussing are the distribution of assets and liabilities, and this is the property that was accumulated during the marriage. You also, at that time, if you had property before the marriage or some other types of property that wouldn't be subject to distribution, it would also be addressed that you're retaining that property. In the context of the financial issues, you have support issues, and underneath support, you have child support and alimony or spousal support, as we call it here in New York, as well as attorney's fees. How will the attorneys be paid for during the course of the case? With respect to custodial issues, we'll address the two types of custody, the physical custody and the legal custody. Legal custody is how the decisions will be made for the children, and the physical custody relates to what the children's schedule will be with both parents.
So if you're thinking that divorce is something that might be on the horizon for you, but you're not necessarily ready to start the process, here are some things that you can be thinking about that will put you in a good position should you decide to go down that path. The first thing you're going to need, and we aren't saying this just out of self-interest, is an attorney that's a good fit for you. So you want to make sure that you do your research on your attorney. And what we mean by that is you want to make sure that you look for somebody who has practices primarily, if not exclusively, matrimonial and family law. You want that because you want not only somebody who's going to be very familiar with the current issues and the current trends in your area, but you also want somebody who's going to be familiar with the bar, meaning all the other attorneys that practice matrimonial law in your area, and with the bench, meaning the judges that potentially could hear your case. Because the matrimonial world is a pretty small world, and many of us know each other. We're before the same judges over and over again. So you want somebody who's going to have that kind of perspective, who can guide you as you meet. In addition, you want to make sure that it's somebody that you have a good rapport with, because it's a difficult process, and you want to make sure that you're going to enter into it with somebody with whom you feel comfortable being honest, because honesty is very important between the attorney and the client. And somebody who you feel like is going to communicate with you in the same style that you have. If you're somebody who needs a lot of hand-holding, who really needs somebody who is going to be available all the time, then you want to think about how available they seemed to be when you tried to set up a consult. You want to think about how available they are for conversations about sort of the emotional fallout from the divorce. If you're somebody who wants very direct, you only want to talk through email, you want to be as concise as possible, then you want somebody who's not going to be weighing you down with flowery exchanges and who's unable to adapt to that. So keep that in mind. You also can get started in the process of gathering what you already know are going to be necessary documents for the process. And those include any documents that relate to your spending history for the past, we usually say 3 to 5 years. Given that the last year for most of us has been atypical, we are recommending 5 years given COVID, because a lot of people, when they're preparing budgets for cases these days, are preparing the COVID budget and the pre-COVID budget. So we can get a sense of what your actual lifestyle expenses are when you're in a pandemic and when you're not in a pandemic. Those statements are probably going to be any checking and savings account statements, any investment account, brokerage account statements, retirement account statements, credit card statements. You may need to also look at utility statements because what you're going to be doing is putting together an average of your spending over a year long. In addition, you're going to need tax returns. Again, I would look the last 3 to 5 years because for many people, income has fluctuated during the pandemic. So you want to get an accurate sense of what you can expect going forward. So you're going to want 3 to 5 years of your prior tax returns. And if you have any concerns, I know Kelly hinted at the difference between marital property and separate property. And that is an issue that will come up in the divorce. What are we actually dividing in terms of our stuff? Is any of it stuff where I have a claim that it's my separate property and not something to be divided? And if you think that you do, you want to collect any documents relating to that. So if it's a gift that was given only to you, do you have any proof of that? Is there a gift letter? Is there a gift tax contribution document? Is there a card? Anything that makes clear that that was a separate property gift. If it's money that went through different accounts, you obviously want to be able to trace that money with account statements. If it relates to real estate, all of the closing documents that might show what money went in or money that went to fund capital improvements. Those are common places where we're going to need documentation for separate property. And if you start the process of collecting that before you're really in the case, then that can give you a real head start. And finally, with respect to custodial issues, frequently a big issue in custody is differences of opinion as to how parenting responsibilities were allocated during the marriage. And if you foresee either that there's going to be some dispute as to how involved the other parent really was, then it's helpful to have a contemporaneous account of what was going on before the divorce case started. And what we often recommend is that people get just a calendar book and they make notes for themselves. So if your complaint is that the other parent tends to stay out late, although that's less common these days during COVID, but if there's a concern about when they get home from work, or if there's a concern about what kind of socializing they do outside of the home that impacts the parenting responsibility allocation, you can just keep notes about that. Didn't get home until midnight on this night, didn't spend this weekend away, whatever it might be. In addition, another common concern with parenting responsibilities is parenting responsibility, the capability. And that may be impacted by substance abuse, by an overuse or abuse of alcohol, and sometimes by mental health concerns. And if any of those are concerns that would cause you to question the parental judgment of the other parent, that might cause you to be concerned about the children being alone with the other parent, then you want to make notes of what incidents there are connected with that you're seeing. So if there's an event where somebody's severely intoxicated and the child wakes up at night and the other parent is unable to hear them cry because they've passed out, you want to make a note about that. If somebody's violent and there are any violent episodes or prone to anger, you want to make a note about those things. Because when you're in the midst of a case and somebody's, your lawyer says to you, oh, okay, you have concerns about the other parent's parenting capabilities, tell me why. You want to have, you're most credible if you're able to point to some record that you made contemporaneously with the behavior, because it makes it seem more relevant, more accurate. So that's something that you can do as you're contemplating whether this is a path that you really want to go down.
Just a few points to what Emily said. When you're gathering your financial documents, keep in mind whether your spouse knows that you're considering this, because if you have to go to the accountant, think about how you're going to approach the accountant, because if you're not somebody who normally has contact with the accountant, he or she might mention it to your spouse the next time he talks to your spouse and says, oh, I heard from Mary, she wanted copies of the tax returns. So just that's something to keep in mind when gathering documents. If you have joint accounts, if you're billed for the records, a statement might go out to the house and your spouse might get a copy of the statement. So those are all things that we as practitioners deal with. So it might be something you want to hold off on doing until you've actually engaged a lawyer who can guide you on that approach and how to approach gathering records.
That's a good point. Also, Kelly, just to build on that, if, as is often the case, if you and your spouse are jointly having this conversation about whether this is something that you might want to do, this process of collecting documents also, on the other side of the extreme, it could be something that you do together and you allocate that responsibility jointly.
And Emily, when she was talking about journaling, she mentioned having a calendar. We've seen clients use apps these days that are on their phone. Totally fine. Just be mindful if the information is shared or stored on a cloud. That way, if that's a cloud that's shared by your children or by your partner, they may have access to your notes, and it might not be an issue that they see your notes, but the fact that you're keeping notes might raise some red flags. And to Emily's point about keeping the notes, it might not be done for any type of sneaky reason. It's just a matter to keep a log in real time. So if you have to have that recall, you can look towards your notes.
And actually, that's a great point. Having raised that, if you are feeling that there are things that you're having email exchanges with friends or even with possible lawyers, any kind of online presence that you think potentially should not be revealed to your spouse or to your children, you also want to make sure that things like email passwords or automatic sign-ins are covered, so that you don't have to worry that your child's going to open up your Gmail account and see some subject line divorce, or that your spouse will.
Right. And then in terms of even keeping the notes, while it does go to credibility, we find often when we have clients who live in circumstances where there is domestic violence or there is alcohol abuse or just maybe anger issues, they become so desensitized to it that they don't even realize that those are issues, right? And so they don't have that immediate recall or even think about that being a problem because it's something that they become used to. So by having these notes, you can present them to your lawyer, and they might spot issues that you just can't see. So moving on to the financial issues that exist in a divorce, we're going to talk about the child and spousal support. So you'll see on the slide, we talk about we're going to talk about how is it calculated, who receives it, who pays it, and what does it cover. So in New York, with respect to children, there is a payment called child support, and it consists of a basic child support payment, which is a monthly sum that goes to the primary parent or the parent who has a larger share of the time to use towards the children's housing, food, shelter, and other basic expenses. Now, in a situation where the parties have about equal time, the payor of the child support is the one who has a greater amount of income. Okay, so where one party has more time than the other, the party with more time receives the child support, the other one pays the basic child support to that parent. Where it's equal, it is the party who has the greater amount of income who is the payor. Now, I referenced basic child support. There is also something we refer to as add-ons. And add-ons are, in addition to the basic child support payment, where each parent, there will be a contribution. It might be from both parents or only one parent towards the child's unreimbursed healthcare expenses, health insurance, and childcare expenses incurred while a parent is working or getting education or the skills necessary in order to find employment. In addition, an add-on expense might also include a child's educational expenses, as well as a child's extracurricular activities and summer activities. And if both parents have income, they will both be contributing on some sort of, basically it's a pro rata share, their income versus the total amount of income between the two parties. With respect to the add-ons, it might be that it's paid directly to the provider. It might be that it's paid to the party who actually paid the provider. So there's all different ways to do it. But typically we always advise to pay it directly to the provider, so then you could avoid doing true-ups between parties. In addition, there's spousal support. And once you've determined that an individual is a spousal support candidate, and that's somebody who is not self-supporting, the party who has typically paid for the expenses during the marriage, paid for the lifestyle, they will pay a sum of support, what we call spousal support here in New York. We've also referred to it as maintenance, I would say, over the last 10, 15 years, but I feel like as though there's a trend away from the term maintenance to post-divorce support or spousal support. Both the spousal support and the child support are based on statutory formulas. And with respect to child support, the court will look at income up to $154,000. With respect to spousal support, the courts will look at income up to $192,000. Now, The courts also have discretion to consider income that a family has above those amounts, and those are it's a factor-based analysis that the courts will do. During the course of the case, we refer to the support that's paid to a party as pendente lite support, as temporary support, interim support. So there's support that's paid while the case is pending, and the reason that is because during the course of the case, you have to work on issues such as what the final amount of support will be, how the assets and liabilities will be distributed, and what the custody arrangement will be. So during that period of time, you'll try to reach an agreement as to what those amounts should be, or a court will have to order what those amounts should be. And then there is what I referenced earlier is post-divorce maintenance, which will go on for a period of time. There are guidelines in a statute for the spousal support. They're only guidelines, they're not mandatory, that speak to how long the support should be paid for. With respect to child support in New York State, a child is emancipated for custody purposes at the age of 18. However, they're not emancipated for child support purposes until the age of 21. Oftentimes, in cases where we resolve them by agreement, the child support will continue until the child reaches college, the end of college, graduates college, provided they've been attending college on a continuous basis. Emily, is there anything you want to add?
I don't think so. When you talked about income, I think the only thing that I would add is that when the court looks at income for purposes of deciding either who should be the payor for child support, if it's a close to 50-50 custody arrangement, or for basing the amounts of support for child or spousal support. When we talk about income, we're talking not only about what your actual compensation is, but also what other sources of income you might have. If you have other income streams, distributions from trusts that you regularly receive, or interest from investments. And they may also impute income to you if you have substantial assets from which you could or do derive income, or if you're a party who's not working, but the court believes that you could work. They may impute to you a certain amount of income based on your prior work experience, your work history, what they think you could be earning if you were working.
Right. I mean, Emily and I have lectured on child support and spousal support a good number of times, and each of those lectures are anywhere from 60 to 90 minutes. So, like I said in the beginning, we're just really trying to do a very high level with the 30 minutes that we have.
And the other thing I just would note here, I'm not sure, Maggie, if we're just not seeing them. It looks to me like some people may be trying to send messages, and like I said,
if you click on the box, I'm responding where I can.
Oh, I can't see.
Okay, great. I was just about to click send on that, but thanks, Kelly.
Okay, so on the custodial pieces, physical custody and legal custody. So physical custody is what we talk about when we talk about where the children are. And what we mean by that is who they're spending time with. And generally, you're either going to have a primary custodial parent and the other parent has parenting time according to some schedule that is less than half the time, or you do a 50-50 arrangement where each parent has 50% of the non-holiday time, and you can do that according to whatever schedule works for the family. Now, when we say non-holiday time, generally when we do an agreement, there's the primary custodial access schedule that will be in place for the day-to-day, and then there's also a holiday and summer schedule that's going to be different because we allocate those holidays in a different way in accordance with whatever makes sense, again, for the family in question. If you have a primary parent, I think one of the first things to note is that we see much more of a trend these days toward a presumption of a 50-50 schedule as opposed to a presumption of a primary parent with access for the other parent, which is a bit of a change and often is different from what was the marital arrangement. We have clients frequently who will come to us and say, during the marriage, so-and-so was responsible for going out and earning a living and providing, and the other parent took on the bulk of the parenting responsibilities. And even if that was the distribution of tasks during the marriage, it's not uncommon when you get divorced for the parent who was the provider to say, number one, the parent who wasn't working probably should start contributing to their own support now that we're no longer married. And number two, I would like to step up and take on a larger custodial role. And the courts are saying that they agree that that makes sense, assuming that there are no concerns about parenting ability relating to substance abuse or mental health concerns that we talked about earlier. So I think, if you have a situation where you have always been the primary parent and it's your expectation that that will happen post-judgment, that is becoming harder to accomplish. So we often make sure that people who are considering divorce, particularly parents who are looking to kind of safeguard a primary parenting role, really consider what the post-divorce custodial arrangement is likely to be and whether that's something that they're willing to consider. Now, having said that, it's not that we don't ever see, that all of our cases are 50-50, but it is becoming more the norm than it used to be. So that's physical custody, and legal custody is how decisions get made for the children. And so in a divorce case, there are really 3 ways that that can happen. Number 1 is joint decision making, in which the parents have to be able to make all decisions together. And if they aren't able to make decisions together, then there may be some mechanism for how they can facilitate cooperative co-parenting before they have to go back to court on everything, which could be, for example, they'll defer to the appropriate professional for a medical decision. Maybe they would defer to the doctor for concerns relating to education. Maybe they would defer to the therapist or to the guidance counselor at the school, those kinds of tiebreaker provisions. If it's not possible for parties to make decisions jointly together, if they simply can't co-parent in that way, then the 2 options are one parent gets sole decision making, which is very rare and really only is going to happen if there are serious concerns about the judgment of the other parent. And there would have to be a documented history of that parent not being able to productively and constructively make decisions on behalf of the children. If it's not going to be sole custody for one parent, but it also is not a relationship that would allow realistically joint decision making, then we have what are called zones of decision making. And there are really only 3 areas of major decisions for children under the case law. Those are religious decisions, medical decisions, and educational decisions. This past year has been sort of interesting in that I think COVID has highlighted that there are some things that are hard to place, right? Does the child go back to school, for example? Is that an educational decision or is that a medical decision when the concerns are that there's a pandemic? So there is overlap clearly, and that can be an issue when you're assigned zones for decision making, because if one parent has the medical and one parent has the educational, and there's conflict as to where this decision gets placed, then that makes it hard to have a clear directive in terms of who gets to make the decisions. But mostly that kind of zone helps to minimize conflict, minimize communication, and the need for the parents to engage together.
Okay, so we're going to go on with our last few minutes to practical tips. And I think this is one of the best ones we can give, is how to keep costs down, because the process can get expensive quite quickly. And I think the best place to start is find a lawyer that you trust. You can really probably get a sense from your initial interactions with the attorney whether this is somebody who is just going to churn fees in your case, or is actually going to be mindful that you're an individual paying for the case. So be mindful of the lawyer you pick. That should be a consideration when you're interviewing attorneys. Also, try to minimize communications with the lawyer. Perhaps instead of something happens during the day, immediately sending a text message or an email, maybe just keep up a draft email and contribute it to it during the day, and then at the end of the day or the next morning, review it. Maybe you'll want to remove some things, edit it. Not want to waste the attorney fees on a particular issue that seemed like a huge issue the day before, and then send it off to your attorney. Another way is to participate in the process. For example, one of the documents we always complete, whether we're in court or out of court, is a net worth statement. The more that you can do by gathering your documents, organizing your expenses, will cut down significantly on cost. How to engage with your soon-to-be ex-spouse, also how to handle disagreements and when to raise them with your lawyer. I mean, ideally, you are going to be engaging in an amicable way, or at least in a similar way if it was an appropriate relationship when you were together. But assuming it's not, always assume that the court is going to read your communications, because it's attached. Either you've attached it as an exhibit to a motion, or your soon-to-be ex-spouse has attached it as an exhibit. Also, what is just pervasive these days is recordings, because everybody has an iPhone or an iPad. So assume you're being recorded, as unfortunate as that sounds. Dating during divorce. Answer, yes, with some caveats. And I'm not plugging us at all, but because we are low on short on time, Emily and I just wrote an article for Thrive Global. It was published on October 16th with some tips for dating during divorce. But the short answer is yes. Can you do it? Is adultery a crime in New York State? Yes. Has it been prosecuted in decades? No. But you always have to consider the children. You have to consider whether your dating is going to somehow shift your focus from really focusing on your case. But we also recognize that you have to have a life and you have to focus on your well-being. So also, dating profiles, be really mindful of those, because they are available to the public, and you definitely don't want to have your children in your profile, but whatever is in your profile could potentially show up in your case. So keep that in mind.
Also consider who you're choosing for a partner. Maybe don't date the nanny, don't date the neighbor,
or anybody at work, at your
don't
office.
Date your son's best friend's parent. Those kinds of sensitivities are helpful.
Right. Or your friend, your wife's or your husband's best friend.
Right. Well, I don't know. Maybe. That one I'm okay with.
Is he rich? Based on money.
So I'm not sure, Kel. I can't see any of the questions, so I don't know if there's anything that requires follow-up or discussion.
Okay, so there is a question submitted by Savvy Ladies, and the question is, I'm afraid my husband would outlawyer me in a divorce. What could I do to prepare? And I think what you're asking is, he has more resources to spend on legal representation, and the good answer is that we actually have a statute here in New York State that requires the parties to be on equal footing. And there is a presumption that the moneyed spouse will pay the non-moneyed spouse's fees. But it's definitely not a blank check, and it also let me just say this: if somebody's misbehaving and spending a lot of money, they will eventually it will catch up with them down the road. But the goal is in the beginning that your fees are covered by the moneyed spouse, and it might be that you have to make an application to the court to get that fee award. Ideally, you have your attorney reach out to the other side and try to negotiate some payment up front for you to pay your retainer fee. But it's a natural concern. We see it in most of our cases when we represent the non-moneyed spouse. And it's something that when you retain your lawyer, you'll have an extensive conversation about how to deal with.
I would also say this is another area where being as prepared as possible before the process starts is going to be helpful to your lawyer. You want to give your lawyer as much information, as much knowledge as possible so that she's armed with that when going into court against your husband's attorney. So this collection that we talked about will help you get a handle on your financial circumstances. We commonly see people who will come in, particularly the non-moneyed spouse, and they really don't have any understanding of where the money is kept, what accounts there are, what the overall financial picture is. And that's fine, because we can figure that out as the case goes on. But to the extent that you can start to answer some of those questions before you meet with a lawyer, you'll be in a better position.
Thanks, Kelly. Thanks, Emily. I do have another question for you, if it's if you have time for another one.
Sure. And I also see, Maggie, that there's one in the chat. I don't know if that's the one you're referring to.
I did see that one just come in. Yeah, I can read you the chat one. Says, I've been a stay-at-home mom with no income. My husband took all our savings from our joint bank account and moved it to a new private account. How do I retain a lawyer without any funds?
So in that sort, I think Emily really we both sort of spoke to that, but you have to talk to your lawyer. I know this sounds not very helpful, but they would explore with you whether it makes sense that maybe you borrow money from a family member or a friend in the first instance, and how to document that loan. Might make sense to put it on a credit card, or it might make sense for your lawyer to reach out to your husband's lawyer. So simply because they move the money out of your control doesn't mean that you're not entitled to use that money to pay for your legal fees. Or, if there is a party who is commandeering all the assets, then maybe we have to look to their income, which is also, something that the lawyer should discuss with you, because it's not necessarily that assets will be used to pay for a divorce. It might be that a party's current income stream is used to fund the divorce.
And I would also, the only thing I would add to that is that it's a very scary situation to be in, to have no resources and to feel that the only money that you were aware of is now disappeared. That can be undone. There are account statements. He will have to account for where that money went and how it was applied. And if it wasn't applied in a way that was appropriate, he'll have to put money back in the pot. So I would also say it's perhaps not as scary as it feels, although I know that is a very scary situation to be in initially.
And that's also a good place to really evaluate what kind of lawyer you have, right? Because in that circumstance, I would do my best to make sure that we've thought about all of our options without rushing to court right away, right? Because that could be an expensive process. And so if you're trying to get your retainer fee from, paid by your husband, next thing you know, you've used it all trying to get that retainer fee, which makes no sense, right? So you really want a lawyer who will be creative and consider all the options without going to court in order to get it paid.
Okay. Thank you, Kelly and Emily. I have another question for you that came in over email. And this question is asking what to do if your ex moves to a different state, maybe in a few years from now. Would the custody agreement have to get redone?
So yeah, that it's interesting the way it was phrased. Initially, I thought that question was going in another direction, which is something that we've seen a lot of in COVID, which is parents who have relocated initially intending for it to be a temporary relocation, and then there's some dispute between the parties as to whether that relocation should become permanent, and then there's a fight about where we should be locating the family. Are we going back to New York? Are we staying in a new place? And that is a sort of a separate issue. For future relocations, after you already have an agreement in place, your agreement likely will, and certainly should, if this is a concern of yours, have what we call a geographic restriction clause, and that clause will
identify. Clause, right? I think radius clause is the more
radius clause, and that provision will identify the boundaries through which you and your spouse can move with the children, and any move that extends beyond that radius would have to be done either with the agreement of the other parent or with the court's permission. So with a clause like that, you don't have to be concerned that your spouse can just pick up and move to Texas. And if the agreement is such that you would allow them to pick up and move to Texas, if that's something that you're open to, then I think you would probably have to re-examine the custody agreement, unless it's your intention to also move to Texas, because you would want to, generally in a circumstance like that, make sure that the parent who remains in New York is getting the bulk of the non-school time in order to kind of try and equalize the access.
Okay, thank you. And we do have, I think it looks like one more question for you, which is asking or saying, I'm curious to know what you found over the years are things that women forget to ask for when it comes to settling finances in a divorce.
Interesting. Forget to ask for.
I guess it would be what we've seen on the other side, because our clients never forget anything.
Exactly. I was going to say.
I hope you've been excited that the other side has forgot to deal with. I think always it's silly, but like one of the issues that sometimes can get overlooked until the very end is our airline points, frequent flyer miles, hotel rewards, and those are you can't put really a good. It's not like a penny of it's like a penny a point or something, right? So you always want to sort of be able to allocate them without having to put a dollar value on them, because you don't really pick it up with a dollar value. But I think making sure you get those miles, and sometimes because most of the accounts we find are in the husband's name or the higher earner's name. So if there are companies that don't allow the points to be transferred to another individual, so you might want to try to do a trade in some other way.
You also want to make sure that you and your attorney have a firm understanding of what your actual expenses are, because if you're going to need to be cutting down your expenses in order to manage what your post marital resources actually will be, you want to have a clear understanding of which ones are malleable and which ones aren't. And I think one that sometimes does get overlooked, a big one, is health insurance.
Right.
So frequently when women are looking at their financial picture, they don't think about health insurance because they've always been covered under their spouse, and that is a big expense, and you will pick that up post-judgment. So you either want to arrange that it's going to increase the amount of your monthly support so that you can make that payment, or you can arrange that your spouse will pay for your insurance coverage for a certain period of time.
And also, just one point on the health insurance, if you have to get it off the marketplace or you're electing COBRA, it's going to be more money than maybe it was before when there was a portion being paid by the employer. The other thing that we always address very early on with women, particularly ones who haven't been in the workplace, working outside the home, they've been stay-at-home parents or just a stay-at-home spouse, is what are your skills? What are you interested in doing? Because the law is such that you will not be getting spousal support probably for a very long time. You will probably have to go back to work. And so we really encourage people right away to start thinking about that. And then inevitably the client will say, well, isn't it better if I don't have a skill or I don't have a job, because then I'll get more in support? And the short answer is maybe yes, but it's going to be for a very finite period of time. But also in our experience, we found that there's a lot of respect and credibility given to parties who show an effort to become self-supporting, with both men and female and male judges.
And it undercuts, I spoke briefly about this idea that the court is going to impute income to the non-working spouse with the understanding that they will be able to earn money at some point once they choose to work. And if you have already made the effort to become employed and appropriately employed, then that rebuts any argument that you should be imputed income more than what you're actually making.
Mm-hmm. Okay. Great. Thank you, Kelly and Emily. I want to thank you for a really excellent presentation, and I want to thank you for taking the time to answer our questions today, especially on a topic that can be pretty scary for a lot of people. So thank you so much for taking the time to walk through it with us today.
Of course, we're happy to do it.
Yeah, thank you.
Okay. Thanks, everyone, for joining us today. Thanks again, Kelly and Emily. It was great.
Thanks, Maggie.
Bye-bye.
Bye.